Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's Monday. I got up early this morning. Wasn't really paying a lot of attention to the Supreme Court orders list, but lo and behold, news broke that the orders list was out, and shockingly, we have our second gun case being accepted this year by the United States Supreme Court already. Is that good news? Actually, I don't think it is, and I'm going to explain why in just a moment. So today, let's spend a few minutes, let's get you all up to speed, and let's talk about the Supreme Court accepts another gun case. Okay, America, we're going to talk about the Supreme Court, which has now accepted for this term its second gun case for the term, which is two more than it normally accepts. Is that good news? I'm not sure it is, and I'll explain why. The case we're talking about today is United States v. Hemani. We have talked about this case before. This is a challenge to 18 United States Code Section 922G3, which is the federal prohibition on those who use unlawful controlled substances from possessing a firearm. Now, I have had a beef with this law, and my beef is this, is that we have a historical tradition of disarming individuals who are actually under the influence of a controlled substance at that particular moment. There's no debating that. But do we have any type of historical tradition that just says, well, we get to ban people 24 hours a day, 7 days a week, 365 days a year because they use controlled substances? Now, here's the thing. This oftentimes comes up in the realm of marijuana use. Why? Because we got a whole bunch of states in the United States right now where that is actually legal. And so the question I've always posed is because somebody goes home on a weekend and smokes a joint sitting around watching a movie one night on a Friday night, does that mean that they should be disarmed the other 6 days of the week? Well, right now, under federal law, the answer is yes. So normally we would be really super excited to see the United States Supreme Court taking this case, especially with the current makeup of the court. But let's go back in our time machine to see what happened here. Because you see, when Hemani was indicted under charges under 18 United States Code Section 922G3, the Fifth Circuit actually found that most of this law was unconstitutional as applied to Hemani, which means that it is the United States government, the United States Department of Justice, that has asked for petition to the United States Supreme Court. It is the United States Department of Justice that has been granted this appeal, and it is the United States Department of Justice that's going to try to overturn the lower court's ruling. Translation, the United States Department of Justice is hell-bent on preserving this law. But much like the Hemani case, and we have talked about how that case has come back and haunted us time and time again, and this is something you learn like the first week in law school. Every law professor will tell you that bad facts make for bad law. And the problem in the Hemani case is there is all sorts of bad facts. Take these, for example. Respondent Ali Hemani is a dual citizen of the United States and Pakistan whose actions have drawn attention of the Federal Bureau of Investigation. In 2019, a search of his phone at the border crossing revealed communications suggesting that he was poised to commit fraud at the direction of suspected affiliates of the Iranian Revolutionary Guard Corps, a designated foreign terrorist organization. Yeah, that's the named defendant in this case, but it gets worse, because check out these allegations. In 2020, respondent and his parents traveled to Iran to participate in a celebration of the life of Qasem Soleimani, an Iranian general and terrorist who had been killed by an American drone strike the month before. But it gets worse than that. Respondent's mother was captured on video telling an Iranian news agency that she prayed that her two sons, including respondent, would become martyrs like Soleimani. His brother apparently also has ties to terrorist organizations, and the allegations against Mr. Hemani also claim, and respondent has told law enforcement officials that if he knew about an imminent terrorist attack by a Shia brother that would kill innocent people, he would not report it to the authorities. So this guy doesn't really sound like your typical pot user, does he? No. Well, that's because he's not, because check out these allegations also. Respondent is also a drug dealer who uses illegal drugs. Text messages recovered from his phone showed that he used and sold promethazine, and he found that substance addictive. He also used cocaine and marijuana. And then when the FBI finally decided to do something about it, what did their raid uncover? Well, the FBI obtained a warrant to search respondent's family home. Agents found a Glock 9mm pistol, 60 grams of marijuana, and 4.7 grams of cocaine. Respondent told the FBI that he used marijuana about every other day. He also told the FBI that the cocaine, which had been found in his mother's room, belonged to him. And of course, that leads the United States Department of Justice to have pled in their petition for certiorari to the United States Supreme Court to argue the Fifth Circuit erred in holding the Second Amendment precludes Congress from restricting the possession of firearms by habitual users of illegal drugs. The court's decision invalidates an important federal statute in the vast majority of its applications and exasperates a multi-sided circuit conflict. This court should grant petition for a writ of certiorari and reverse. Okay, so reason number one that Washington gun law is not really excited about United States versus Hemani being accepted by the United States Supreme Court is all of the facts surrounding Mr. Hemani. You think Mr. Rahimi looked bad? Well, check out the allegations against Mr. Hemani. Now, I recognize that these allegations could be false or only partially true, but even if only partially true, these are pretty salacious allegations, and this is certainly not the type of individual that the United States Supreme Court is going to be willing to go to bat for. But bigger and more important than that, let's remember that the other gun case that was accepted by the United States Supreme Court is Wolford v. Lopez, which is a challenge to Hawaii's goofy vampire rule, which even if that case goes our way, is only going to benefit a bunch of people out there in the state of Hawaii. It's going to have no broad application across the nation. Now, this challenge to 18 United States Code Section 922G3 certainly could have a much broader application. This is not the only case that's been kicking around in the federal court system on this issue. And for all of those states that now have legalized cannabis, this is an immensely important issue. Yet, with the importance of that issue about to be argued before the United States Supreme Court, the vehicle by which this issue will come to the United States Supreme Court, unfortunately, is Mr. Hemani. Finally, do you honestly think that the United States Supreme Court accepted this case so they could go, ditto, yeah, the Fifth Circuit got it right? Absolutely not. But here's the other thing I want you to consider. How much more bandwidth does the United States Supreme Court have to deal with any more gun cases this term? We already got 2. That's 2 more than what we normally get. And let us remember that we got assault weapon bans out there kicking around. We got the Veramontes case right now sitting before the United States Supreme Court. We have the Lamont case out of Connecticut sitting before the United States Supreme Court. We're going to end up with a whole slew of other cases coming out of the state of Illinois. Let us also remember that we have magazine ban cases currently petitioned before the United States Supreme Court, including Duncan v. Bonta, the granddaddy of them all, and Gators Customs Guns versus State of Washington. Does the United States Supreme Court have the bandwidth? Do they have the energy, the wherewithal to actually take a third gun case? Well, that remains to be seen, but the smart money is on the fact that the answer is no. So with that in mind, United States versus Hemani has been accepted for argument before the United States Supreme Court. We will do a follow-up video once they set the oral argument dates, and we will carefully track this case as we get closer to oral arguments. We're going to go ahead and link up the orders list down below. They're pretty boring to read, but you don't have to take our word for it. You can just geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.